Today's date is August 17th, 2021, and the court is hearing case number 29892, City of Barberton versus Philip Ridgeway, via Zoom. And this morning's panel, as you can see, is Judge Callahan, Judge Sutton, and myself, Judge Teodosio. City of Barberton has waived its oral argument, so Attorney Heller, on behalf of Mr. Ridgeway, you will have 15 minutes to present your argument. I'm going to ask Judge Callahan to keep track of the time for me, and she'll let you know if you get close to that. You're willing to accept that duty, Judge Callahan?
I do.
All right. Well, thank you very much for doing that. We've read the briefs and are prepared to proceed as soon as you are. Go ahead, counsel.
Thank you, Your Honor. May it please the court. We're here today on a case that involves issues of constitutional free speech and protection. In addition to that, the other true issues are the use of character evidence and what effect that might have had on the jury in this case. And lastly, we go back to common law for issues of property. The reason I did ask for the oral argument today is I think it's very important to understand the nexus here, both between the free speech issue and the property issue and how those two things directly relate. First off, and most importantly, the case is an issue that does need to be reviewed de novo, as this is a free speech issue. And the speech in question here was a magnetic bumper sticker being altered to say, do not elect the mayor of, re-elect the mayor of Green. By doing this, this is political speech in its purest form, as it's directly related to elections, those people who we place in local government, and what they intend to do. So with that issue, this is the most protected speech. The question really becomes, is this criminal mischief, and would that crime or potential interweaving of both protected action of making a political statement and the unprotected action of modifying a sign be something that should be protected? Because the ultimate question is, did he have the right to modify this bumper sticker? I would argue that he absolutely did have a right to modify this. Going to common law, when we have abandoned property, the person who has it has the exclusive right over it, unless there was some actual way to return it to the true owner previous to him. I believe
counsel, under common law, to be abandoned property, doesn't the owner have to relinquish all rights, title or possession with intention, the intention of not reclaiming it or resuming ownership? Was there any evidence? I mean, how does that fit into this case? It doesn't seem like there was a intent to. This was almost a stolen bumper sticker, it sounds like.
Well, the mayor himself actually mentioned that he had about 16 to 25 of these bumper stickers. And he actually said, these are disposable property. You give them away, and when you're done with them, they're to be thrown away. So he also mentioned that he didn't keep any sort of record of who these particular bumper stickers allowed to. So I believe that that indicates very clearly that the intention with this political sign is to give them out and not keep track of who has them and not do anything for the purpose of trying to reclaim them afterwards. Honestly,
was the mayor the owner of this, or was the person who received the bumper sticker originally the owner of it? I would think the latter would be the case.
Well, Your Honor, with the person who testified originally, he actually did not even testify that his bumper sticker was stolen. He simply testified that he had one on his car, lost it, and asked for another one. So he made no report to police, was never made the victim of the actual crime, if there was a crime. So I don't believe that that person had any property rights to this particular bumper sticker at all, as he didn't even make that connection. And so the only person who could potentially be an owner of the bumper sticker then would be the mayor of the city of Green. However, in this instance, when he says that it's typical for these things to be thrown out, to be disposed of, and that he views it as a disposable property, I don't believe he had any intention to reclaim it or maintain any ownership rights to it after it's dispersed in the community.
Counsel, is it my understanding that this particular bumper sticker was magnetic?
That is correct, Your Honor.
So it was easy on, easy off, so to speak.
Exactly, Your Honor.
Then
And then-
at what point in time, if any, did your client assume ownership of it?
I believe once it was affixed to his car, he assumed the ownership.
Okay.
So in this situation here, there was testimony from 3 witnesses, including his wife and 2 friends, that he particularly asked them, did you place this bumper sticker on my car as a joke? Because they had a jovial, practical joke relationship where that was a typical occurrence. Once the bumper sticker is on his car, it becomes attached to his car for all intents and purposes, and I believe a part of his car. So then he has absolute right to remove it, take it off of his car, and do whatever he wants with it. Just like even if it was a sticker, a true glue and paper sticker that had been placed on his car, if it was something that he did not approve of and didn't want on his car, he would have the absolute right to remove it or do whatever he wished with it after it became affixed to his car.
So
other
your
thing-
argument then is I'm sorry, whoever I just talked over, once he assumed ownership, then he had a First Amendment right to express himself.
Yes, Your Honor, exactly. The other thing I would liken it to is you park your car in a parking lot and you come out and you find a flyer under your windshield. Once that flyer is under your windshield, you don't have an obligation to go to Sam's Hardware and say, hey, you left this flyer in my car, please have it back and give it to the next person. You can crumple it up, you can spit your gum in it, you can do anything you want with it because it is affixed to your car and you can dispose of it. So I believe it's really akin to that kind of situation here.
The fact, your argument would be different, I'm assuming, if and I forget the gentleman's name who originally had the magnet. If he had made a police report with that would be a different scenario, different argument? Because it wouldn't have been abandoned?
Yes and no. I still believe that there would still be the burden on the state to prove beyond a reasonable doubt that this bumper sticker is the same bumper sticker that gentleman lost. The state had no witnesses who were able to do that. So I don't believe the state would even be able to be successful in that, right? But had he claimed his bumper sticker was stolen, he would have a better cause of action here than the mayor. Yes.
That answers my question. I don't want to take up too much of your time.
Absolutely, Your Honor. And kind of with this issue, I think that you've hit the nail on the head. There's very, very little case law dealing with criminal mischief and abandoned property. One of the only cases I could find involved a car, which is different because of the significant value, saying that when there's an abandoned car, the state has rights to that before someone can go and just pick parts off of it. But for something like this, that is so disposable and so movable, there's literally no case law, and that's why we have to go back to the common law. And when we look at that intersection here, another analogy that was given by counsel at the time of the trial was as if a yard sign after a storm blows into your yard, what is your obligation to do with that political yard sign? Do you have to go door to door to find the true owner? Or can you do whatever you want with it after that time once it has blown into your yard and it's there? And I think that the answer for this is very clearly, you're able to dispose of it however you see fit, because it's an unreal expectation to place on someone to try and find the true owner at that point. Likewise with this bumper sticker, it would be an unreal expectation to do anything else with it. So for that reason, I believe Mr. Ridgeway was entirely within his constitutional rights to modify it to make his political statement.
What if the mayor had seen Mr. Ridgeway driving with this magnet unaltered, as you say he did at some point in time, came up to Mr. Ridgeway and said, I want my magnet back? Would Mr. Ridgeway have to give him back that magnet?
I think in that situation, given that it's his political sign and it's unaltered, he would have a right to ask for it back. Whether or not that occurrence would ever happen in reality, I don't know. But I believe in that situation, because Mayor Newberger was the original owner, he would have some property claims under common law. So I believe that he could ask for it back at that situation.
Counsel, I have a question for you that, I don't know, just because I was thinking this the entire time I was reading the briefs, and I don't want to take up a whole lot of time because I know you want to get to those evidentiary issues, but what if your client had been charged with receiving stolen property?
Well, Your Honor, I think that there's still going to be a very difficult burden of the state in that case to prove that he would have knowledge that these bumper sticker is stolen. Given the disposable natures of these things, unless there's some witness the state has that can prove that there was knowledge that this was a missing item that had that actual value, I think that that would be a burden that the state couldn't prove beyond a reasonable doubt.
Okay.
Just very briefly, I would like to touch on the improper character evidence in this case. I believe it's an important part that led the jury to losing their way in their ultimate decision. So when looking at this case here, improper character evidence is very important. The rules of evidence state very clearly that only certain crimes can be used to impeach the credibility of a witness. Those include, of course, felonies, as well as crimes of dishonesty. And in the intent to use anything beyond that, there are very clear requirements to prove motive, intent, and common scheme identity. The questions of motive and intent were not even at issue here. It was very abundantly clear that Mr. Ridgeway placed this on his car to make his political views known. It's very clear at the issues of identity that Mr. Ridgeway is saying this bumper sticker is on my car. He posted it on Facebook for the world to see to spread his political message. So then it becomes an issue of why are we allowing in this character evidence?
Counsel, am I, again, to understand that the case didn't put this in its case in chief? It came in during cross-examination of your client?
No, Your Honor. It actually came in the case in chief on a redirect of the mayor. And this is problematic for multiple levels. Number one, under 609, any sort of criminal record needs to be introduced by clerk of courts or by certified record, and it wasn't done so. So the mayor was actually allowed to basically use hearsay to bring up past criminal convictions of misdemeanors that weren't even similar in scope or anything. However, and he was allowed to bring in hearsay of things where no crime was even charged. So to go directly to the nature of Mr. Ridgeway's character and to taint that in the eyes of the jury. So this wasn't done after Mr. Ridgeway testified. This was done well in advance of his testimony. It was brought in both through the mayor as well as through a police detective who testified he had no direct involvement in the previous investigations. However, he knew of these convictions. So by virtue of doing that, we completely skirted Rule 609, and it doesn't fall under any exception under 403 or 404. And by virtue of allowing this in, the judge's reasoning in this case was to say that this was being done for the purpose of rebutting a presumption that this was political payback. However, that's not a proper purpose. And in addition to this, it was very clear at the trial that the state knew of these convictions ahead of time, and had the state had the intention of using these, or even thought that they may have to come up at trial, they should have submitted a 404 brief to the court in advance, so the court would have had time to adequately prepare, research, and know how to rule on these issues instead of doing it on the spot. So by virtue of not even providing any sort of 404 or 403 brief, it became a trial by surprise, a trial by ambush on this particular issue. And this created a picture of Mr. Ridgeway that he is a troublemaker who continually instigates things specifically around elections. And ultimately, this can be seen in the judge's sentencing, which is one of the most politically chilling sentences I've ever seen. Mr. Ridgeway, on a misdemeanor of the 3rd degree, was sentenced to 5 years of probation, specifically with 60 days of Scram X house arrest bracelets to be installed during the course of the next 2 elections. And when that's being done, the judge's words were, this is being done, and I want to try and read this. It's in my brief, but I think it's important to understand that this is being done to say during the next 2 elections, I want to make sure you're not drinking, and we want to know where you are so you won't be causing any more of these teenage antics or trouble. So in essence, the sentence of the trial court is designed specifically to say during the elections, you are being watched by the state of Ohio, and in the event you act out or cause any sort of trouble whatsoever, we have the ability to impose the 60 days of suspended jail time. So this sentence is chilling to free speech, and I think also directly related to the improper character evidence that became rampant in this trial.
Counsel, your time is up. If you just wanted to do a last summary statement or so.
I would close with this, Your Honors. Property law, going back to common law, says that abandoned property belongs to the owner. And in this case, this bumper sticker was abandoned on Mr. Ridgeway's car. His speech saying, do not re-elect the mayor of Greene is pure political speech at its finest. And when we have situations where there is a question of some speech being protected and some being not for criminal purposes, the case law is clear that we need to err on the side of protecting free speech. So in this situation, Your Honor, I do believe the trial court lost its way, and I would ask this court to reverse.
Thank you for your presentation today, Attorney Heller. The court will take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail a copy of the court's decision to both you and the City of Barberton's prosecutor's office the day it's released. And as you know, the opinions are also posted on the Supreme Court of Ohio's website. We want to thank you again for participating by Zoom, and the court will be adjourned at this time.